opening statements are crucial. I mean, in some senses, for many jurors, they'll say that's what made up their mind, right? They hear it at the beginning, and then there becomes confirmation on what they heard when the witnesses go. So this matters a lot. So let's start with the prosecution. They go first. Prosecution lawyer goes for 46 minutes. So I'm just going to pick one line, but it was 46 minutes. One operative line from the transcript. Donald Trump orchestrated a criminal scheme to corrupt the 2016 presidential election. Then he covered up that criminal conspiracy by lying in his New York business records over and over and over again. Did they do a good job?
I thought so, for a number of reasons. Let's talk about that. To your point, Erin, I think opening statements are simply a preview of what the evidence will show, but you have to maintain credibility in giving that indication to the jury. Most good lawyers will do what the prosecution did do, and the defense in some measure, which is under-promise and over-deliver. And I think what the prosecution's point of view was, and they said it in terms of your theory of the case, conspiracy and a cover-up. Now, conspiracy is not charged. That has legal significance. Conspiracy to more people engaging in illegal acts. But it kind of is, and here's why. What happens is that from the prosecution's perspective, this was part of an enterprise orchestrated by Trump to interfere with the election. And how did they do that? They did that by virtue of this payment that was indeed reimbursement, says the prosecution, and they had nothing to do with a retainer agreement. And then they talked about the cover-up, right? And so I think to the extent that they put that narrative out there, they being the prosecution, they did their job in wrapping up what they're going to show over and over 34 times, again, as to these fraudulent business records and the intent and purpose, which was to interfere with the election.
And 34, because obviously there was a payment to Stormy Daniels, and that which Michael Cohen says he made. Or he did make, and then Trump, this is how that reimbursement was broken up. So we've got every single one of those checks. Sarah, as a former prosecutor in the Southern District of New York, you really understand the players and what's at stake here. So this conspiracy that they're trying to talk about here with Trump, they say it all begins with a meeting with Michael Cohen, Donald Trump, and David Pecker, the three individuals that we're talking about today, before Trump even announced the campaign. And they say in this opening statement that they, quote, formed a conspiracy at that meeting to influence the presidential election by concealing negative information about Mr. Trump in order to get him elected. And then they continue, and this was interesting, we will never know, and it doesn't matter, if this conspiracy was the difference maker in a close election. Obviously, this all came to fruition 2 weeks before the election. After that, grab them by the P tape, and you had this Stormy Daniels revelation, which we didn't know about at the time because of all of this. Did they do a good job?
Listen, I think they have their purpose here is to present this roadmap and to present a few themes that the jurors are going to take with them throughout this trial. Frankly, I think the research shows that jurors really don't retain much more than those few central themes, so they need to hit those particular themes over and over again. I think the prosecution had to explain the why. I mean, the what is really not in question. Both sides sort of agree to some of the basic facts of what happened here, but they had to explain the why. And they did that effectively. I think 46 minutes was probably too long. I doubt they had the jurors' attention for that long. They probably could have done it in half that time.
Wow, and 46 minutes does sound like a long time. You know, when you tell people you're giving your best man speech or whatever, you know, you say shorter is better.
In this case, though, Erin, I mean, 46 minutes, I wish I could keep my openings to 46 minutes. There's a lot to get out there. Right. I think it was short in the context of, you know, what they had to explain.
All right, so Jeremy, you were there. So what was Trump's reaction during the prosecution's opening statement? And to this point about being 46 minutes, how engaged was he throughout?
What was most interesting with the former president was just how much he was not reacting to what was going on. You know, we had the prosecutor, we had Matthew Colangelo. He was bringing up a lot of illicit things that Trump is alleged to have done. Yeah. He brought up the affair with a Playboy playmate, the affair with a porn star. He brought up the Access Hollywood tape. And throughout all of that, Trump was not reacting. He was sitting back in his chair. His eyes would close from time to time. And I think it's felt like he was making a point not to react. He would pass notes to his attorneys. There was sort of a note-passing thing, and particularly when the Access Hollywood tape, we noted him and Todd Blanche were sending notes between the two of them. But it's obviously different than what we've seen Trump in other courtrooms, and even earlier in this case. That morning, in the morning, we talked about what the prosecutors would be able to bring into evidence if Trump testifies. And when the judge said that he would allow him to ask about the civil fraud verdict that came earlier this year, Trump shook his head at that. This was before the jury came in. With the jury in there today, as these things were being brought up, Trump was very stoic in this.
Interesting. So it's almost as if he really does know that is the audience now that matters.
It certainly seems that way.
Which is fascinating. So Stacey, you're a criminal defense attorney, and of course you were a former contestant in The Apprentice. So you've got both a personal and a professional perspective on this. What did you see on the prosecution?
Yeah, so I saw it was a smooth and solid opening statement, but I think they missed a really big opportunity. Michael Cohen is the elephant in the room in this case, and he's got a prior conviction. He pled guilty in 2018 in federal court, among other charges, to illegal campaign contributions. And he said out loud in court, I did this at the direction of Donald Trump. And that admission is the key of this case. And I think the prosecution should have honed down on that here and brought out to the jury. They said to them, here are all the bad things Michael Cohen did. We're letting you know now, but you're going to see at the end of the case that you should credit his testimony in this courtroom. And what they missed out doing is saying to the jury, people don't plead guilty to things they didn't do. So Michael Cohen is going to be believable. He took a 3-year jail sentence for this alleged scheme. Trump is saying it's an alleged scheme. Michael Cohen was saying it happened. So they could have tackled the beast, because Trump is going to come out and say immediately, Trump's lawyers, and when Michael Cohen gets on the stand in cross-examination, you're a liar, you're a convicted liar, you've lied over and over again. And the DA needs to have Michael Cohen say, which he will, it's part of his testimony, I may have lied at other times, but I'm not lying here, because I pled guilty to doing this. I didn't even go to trial. Yeah, why would I admit that?
It is crucial that
The one point I would make to that is I think they strategically, in my view, avoided that. And I think there were 2 reasons that they did that. Excellent point you make, and I get it, but I think they were in that room fighting. Should we? I think the first reason is you don't want to put over-reliance upon his testimony. Yes, he's the elephant in the room, but we're going to prove this case not because of Michael Cohen. And the second thing is I think they'll be able to prove it up with other witnesses, with text messages, with emails, with audios that are not relying upon him.
So he
to
doesn't
the extent,
become the center of it.
Correct. So I think they strategically wanted to pivot such that it's not all about Michael Cohen. So when he is ravaged, which he will be, in his perjurer, you lied to Congress, you lied here, they're going to be like, so what about the emails? What about the text messages?
That's right.
What about the audio? What about everything else? That's why we're not relying upon
Which
Michael
is going to be
Cohen.
fascinating, what else they do bring, to your point. And Michael Cohen, when I've talked to him, he says they do have all that other information, that he views himself, in a sense, as additive, not the only way that you would get to this conclusion.
They do, but I'm sorry, I was just going to say that the linchpin in this case are the payments to Michael Cohen as an attorney. And those clips we just had of Trump's press conference today, when he came out of court, he's previewing to the world, this is what my attorneys are going to be saying. This is all worked out behind the scenes before we go to court. He's saying, Michael Cohen is an attorney. It was very odd that he said that today. Michael Cohen was an attorney. He submitted an invoice, and they put the payment to him on the books. And when he said they, I think he was referring to the Trump Organization, so he could distance himself like he knew nothing about this. The problem with Donald Trump doing that is, and this is in the indictment, and the DA said this in their opening statement, Donald Trump signed the checks to Michael Cohen, and allegedly they came out of the Donald J. Trump account. So the whole press conference was a bit of I think, a PR disaster, because it's going to hurt him in court eventually in front of the jury.
And he came out and he does that 8 minutes, Jeremy, talking, of course, in the courtroom. What else stood to you? I know you mentioned that he was passing notes to his attorneys at time, that he was engaged. What were his interactions like with his team and with the jury?
Yeah, it's interesting because when his attorney, Todd Blanche, went to speak, Trump's demeanor, it shifted. He turned his chair, he faced him, which made him face the jury, and he watched Blanche as he went through his opening statement. I think the most interesting thing with Trump today, though, was when David Pecker took the stand, because Trump, he was sitting very motionless, expressionless, really watching David Pecker closely. And there was a light moment in his testimony where he was asked to recount the last 4 digits of his cell phone number for record-keeping purposes, but he fumbled with the answer, and it caused a laugh. David Pecker, he let out this very big laugh that caused laughter in the courtroom. And Trump, his attorneys were laughing, but he was sitting there expressionless, just stone-faced forward, looking at the witness.
So I'll give you a final word on that. What do you make of that? I mean, he is well aware now that everything, I'm sure he's well aware of every comment people make on Twitter about what he did or whether he fell asleep or anything like that. This seems to be that he is, when he turns to the jury, what he looks like, very calculated.
Yeah, I mean, if his lawyers are doing their job correctly, they are coaching him on that part of it. And they are doing everything they can to try to control his demeanor, his facial expressions, his utterances, his note passing, all of that stuff in the courtroom. They will not be able to do that outside of the courtroom, but they're doing the best job they can to control that within the courtroom.
Right, and clearly he's decided it's in his interest for now, right, if he gets to be quote unquote controlled. All right, thanks all of you very much.